What's up, everyone? Welcome back to Conflicts of Interest. This is episode 199. I'm the host, Kyle Anzalone. Joining me today is Patrick MacFarlane from the Libertarian Institute, host of the weekly Liberty podcast, and you've been on the show a bunch of times now. Pat, how you doing, buddy?
Doing good, Kyle. Thanks for having me back on.
Always excited to have you on because I think particularly the cases that we cover, because we usually talk about police stuff when you're on, or China stuff, because you have the great documentary on Uyghur genocide that I always recommend people check out when they want to really know the truth of what's going on in Xinjiang, China. But we always, you have a lot more of a nuanced take. It's not just like a dogmatic, like kind of right wing libertarian take, a reactionary take. You really trying to look down and break down what's happening in these cases. So I'm sure we'll have another great one for people today. Everybody, check out the Libertarian Institute, where you find both myself and Pat's work. I'm in the right hand column, the news roundup. Conflicts of interest. I think right under conflicts of interest is the Liberty Weekly podcast, and that is Pat's show. We're on the Libertarian Institute all podcast feed, so you want to listen to myself, Pete Quinones, Scott Horton, Keith Knight, Tommy Solomons, so many great shows. I hope I didn't leave anyone out there, Pat, on that playlist. So check out the Libertarian Institute all podcast feed, and of course the Libertarian Institute YouTube channel as well. And then if you're not already, find somewhere to subscribe to me or Pat so you don't miss the work that we're putting out. And want to mention before we get into it, Pat, the sponsor of my show, Paloma Verde, PalomaVerdeCBD.com. The promo code is PEACE, PEACE. All the information is in the show notes page, so you can very easily go to there, click on it, and then you see the PEACE, and you get 75 or 25% off when you spend $75 or more. Great lineup of products at Paloma Verde. My favorites are the topicals. Always talking about them, how effective they are, how much I love the menthol smell of the sports cream, and lasts a long time, really helps with any back pain that I have. So everybody, check out the great lineup of products they have at Paloma Verde, and use the promo code PEACE, help out the show, and get yourself some great products. All right, Pat, let's get into it and start talking about these cases we want to go through today. And the first is Kevin Strickland, and I've been covering this on the show for the past couple of months as a Missouri law that allowed him to be exonerated finally, even though there were a lot of people within the Missouri legal structure, like the governor, attorney general, and some of the higher ranking judges that didn't want him out. But I think there's a pretty solid case, and I've gone through it, how the police pressured a witness into identifying Strickland, and most of the other evidence against him is circumstantial at best. And so, with that, it seems that Pat, he's a man who was wrongly imprisoned for 43 years. I mean, that's nearly half a century, that this would be a guy that's entitled to a hell of a compensation for the state of Missouri for what happened to him. And, while I always would say go after the people who did it to him on the individual level, my guess is that some of them might be dead and probably don't have a whole lot of money that they're not getting from, government pensions anyway. So, but in Mr. Strickland's case, he ends up not getting paid. So how the hell does that happen, Pat?
Well, this is part of the problem with having a monopoly justice system. And in the case where you actually are due restitution for miscarriage of justice, it's kind of inverse that the taxpayers would be on the hook for it. So I completely agree with you that if this were a just system, it would be the people who actually did this to him. Like the court system itself, of course, that's taxpayer funded. But in the society that we envision, it would be the courts themselves or the prosecution who would be paying restitution. And in fact, Rothbard wrote about this, I think, in Conceived in Liberty or For a New Liberty, writing about pretrial detention. But I think the pretrial detention rule would apply as well in this case, a post-conviction rule, where Rothbard kind of talked about how if you're holding someone awaiting trial, you either allow them bail, or if it ends up that you try the case and you lose, then you have to pay them restitution for the amount of time that you kept them in prison or in jail, rather, awaiting trial. So It doesn't surprise me. I took a wrongful convictions class in law school, and we were talking about this. It's a double loss, Kyle, because, well, A, you're taking away this person's life, but even if there is restitution that is ordered, these people's lives are destroyed. What someone who's been in prison since they were 18 years old, you give them a windfall of 1.5 million, which is just a pittance compared to the loss of your life. But you have nothing to, I mean, you have no life experience. You have severe emotional problems in many cases. You have no way to function in the real world. You still have to depend on friends and family. And this is a life lost.
Yeah. One thing when even like when soldiers are deployed overseas and stuff like that, they do like transition periods and stuff like that to help people ease back into a normal life. If you had spent like a long period of time in a psychiatric hospital, you would like go through classes and everything. And a lot of times these people are just kind of dropped off with enough, whatever it is. I don't know if it's still like 50 cents on the bus corner anymore or something like that, but at one point, that's really essentially what they gave people. And that is what happened to a man who was wrongfully put in a psychiatric hospital for 2 years in Hawaii. I can't remember his actual name. He gave an alias of Castleberry at one point. But anyways, again, and Strickland gets nothing from the state here. The money he got comes from a GoFundMe. So, and then, so yeah, and as you're talking about, just not knowing how to live in a world where you're just not told what to do all the time by an authority figure and having controlling your life and all of that. I think this guy talked about like the two things he wanted to do when he got out was see the ocean and go to his mom's grave because his mom has since died. If you think about it, 43 years, how many people in 43 years do you think after you get out of jail for that you didn't do it, but even then there's still probably some stigma attached? How many people are there to like welcome you home and to help you like to figure out like how to go to the grocery store, like what things cost? I'm sure the laws for like driving and everything have changed significantly since the last time, and how cars work and all this kind of stuff he probably has to relearn. I know they probably have some access to some classes in jail, probably have like some like computer skills and stuff like that, I hope. But overall, the best part of the guy's life has definitely been lost, to just completely wasted in jail, and all that time being on the taxpayer dime. Another thing, Pat, that I think is really important to point out, and I guess, if there was like an independent prosecutor, right, who in our ideal, case here, that they would have like probably some kind of malpractice insurance or something like that, right? But at least then there would have to be reforms put in place in a case like this, because it would cost the insurance company millions of dollars. There was a recent case in, I want to say Massachusetts or something, where a guy did 20 something years in jail, and then they let him out after that amount of time. Yeah, I think it's this guy here, James Lucen, and he was hoping to get like $46 million, and a jury awarded him, I think, like 6 or 8 million or something like that. But is there any like legal standard of what, like, let's say you're wrongfully imprisoned for 10 years. Is there any legal standard of, you get X amount for per year you were wrongfully imprisoned? And then I guess on top of that, is there any, claim that you could make to say like, I was wrongfully convicted of murder, and so for the past my mama died thinking that I committed a murder? Like, how much money do you, like, how much trauma do you have from that?
Those are hard. Those damages are hard to measure. And in terms of a specific rule, I can't cite one off the top of my head, but I have heard of such a thing, X amount of dollars for a number of years. But in terms of like emotional damage, those are hard to quantify, and you probably have to support it with expert witnesses. And so it'd be a difficult battle. And just kind of a comment on some of the wrongful convictions stuff. The one thing I wanted to make sure I highlighted, Kyle, was the power and unreliability of eyewitness testimony. And this I've talked about this before, and I think on my show and on your show, but eyewitness testimony is responsible for a large number of these wrongful convictions, and it's very powerful. And they talk about it in this article here about how he was primarily convicted, of course, by an all-white jury. And I think that race is something that libertarians would maybe ignore to their detriment in a case like this. I think it does matter. But he was convicted by an all-white jury. The sole survivor was the eyewitness, and later tried to recant her testimony, but was then threatened by the police with perjury. And one of the problems is that juries, they just take eyewitness identifications way too seriously, and they put so much emphasis on it when really speaking, eyewitness testimony is very unreliable. People's memories change. They don't remember situations the same way. There was actually in class when I was taking wrongful convictions, we watched a video where a bunch of things happened in the video, and then right afterwards they try to ask you, like, what color was the suspect's hair, and you don't know. You just can't remember. So your memory fills in those blanks. And when you have, a woman on the stand who's weeping about something really bad that happened to her, that's powerful. The jury believes it. And in this case, it caused a wrongful conviction.
Yeah. I remember, Pat, growing up, and I watched a lot of like CSI and Law and Order and all those shows, and they would have, the victim there, and, especially on Law and Order, it's usually like a female victim, and she's like, I would never forget his face, the man who raped me. But, they're not really sure about it, and at the last minute, they get like the evidence, like the physical proof evidence they need to know that they got the right guy, and, she identified the right person, everything like that. But that's really not how it works. And in fact, there's this recent high profile case, I think from the UK, where an author like wrote a book. I think, I forget the name. She's a somewhat famous author. Her like books have been changed into like Hollywood movies, and it wasn't like until a Netflix producer was making a show about her, and I think like with her, and like realized inconsistencies and realized some guy spent the wrong time in prison. You know what I mean? And yeah, like it's hard to tell somebody, right, who's been the victim of a crime like this, like, you might not remember correctly the man who raped you. But yeah, that is kind of the case. But that, I don't think that's actually what happened here. I think this woman was intimidated into giving false testimony by the police, which is a crime on the behalf of the police a little bit. I think, at least from a statement that a member of her family gave, she had said that she still had like the brain matter of her friends on her. So she was like the survivor. There's 4 people who were shot. She was the one that lived. She still had like the blood and brain matter of her friends on her when they brought her into the lineup. And of course, she picked whoever was they told her to, because she wanted to get that off of her and put this all past her. And I think that is typically what happens with people in a situation where they're immediately, especially in a very dangerous situation, but any kind of very traumatic situation, even if it wasn't particularly dangerous for them, if they saw something very horrific, they don't necessarily remember it, and they want to put it past them. And so then, the cops saying like, hey, just, tell us who you saw and we could put this past you. They're going to pit someone, but then their brain's going to implant that memory of that's the face. But, it's all a psychological game that's been played.
Yeah. And, I was looking through the story, and there weren't a lot of details in this story about exactly what had happened. So, and you've been following this for a while, haven't you?
Yeah, past couple of months on the show.
Okay.
Because there was like the Missouri government didn't want to let him out of jail for whatever reason. So yeah, one thing I remember from the late great founder, one of the founders of the Libertarian Institute, Will Grigg. At the time he died, he was covering the case of Christopher Tapp, who was wrongfully imprisoned, and it's now been admitted and everything, although it hadn't been when Will Grigg had died. But during during his coverage of that, at the end, the government was, I think, attempting to bully him into taking an Alford plea, which would be like, you could convict me, but I think I didn't do it. And it's kind of a way for everybody to just agree to let this guy out of prison, and just everybody goes on with their life. And Will Grigg was really imploring, and I don't know if Christopher Tapp was able to listen, but he was really arguing that, like, hey, don't do this, continue to fight, because that's going to give you the legal standing to then take your fight to them. And so is that like the way it works?
Well, without knowing like the specific instances of exactly what happened, I know I've covered Alford pleas before. Like in law school, I did an appeal on it. Like what happens if one side consents to the Alford plea, but the prosecution doesn't. Anyway, it was an appeal issue, but yeah. So I mean, it's possible. I would think that this Christopher Tapp's attorney would like illuminate the options and the consequences and possible consequences for him. But on like a philosophical level, I think that if you're someone in that position, it'd be very attractive to want to stick it, keep the fight up. But then you have all these things weighing, on your mind, especially like these people who are on post-conviction appeals. This is their life, and in some cases they're willing to kind of take their lickings and then just try and move on. And in that situation, I don't know what I would do. I would think I'd want to get vengeance in any way I could.
Yeah, I guess the hard thing is a lot of times, so let's say they throw out the conviction. A lot of times is, like you were wrongfully convicted, the court recognizes that and throws out that conviction. Sometimes if the prosecution refiles the charges, they will keep you in jail through the upcoming trial. And so like you could spend years in jail after the court has exonerated you of murder. And that's, I guess, a part of it too, right? I think Christopher Tapp was younger. I don't think he had done anything near like 43 years like Kevin Strickland. But looking at this guy, and I'm not trying to be mean to him, but like he's not in like the greatest health. Like I'm not saying that like he's on his deathbed, but like he's probably aware that like I could have a heart attack at some time, and like that could be it, especially if you're in jail. Like you're not going to get the best health care. And so maybe for in some cases you just gotta like, I have an opportunity to leave jail now, and I'm going to go and just get the hell out of here while I can, rather than like, feeling like you could fight another day, but maybe it's a trap. And I'm sure a lot of these people, who are wrongfully convicted, like really can't believe, maybe some people can and everything and are like, yep, I knew this is how the system worked. But I'm sure other people are just like astounded that they got railroaded by a system for the crime they didn't commit. And, like what it must feel like to like have, I'm sure like, certain members of their family thought they did it and stuff like that. I mean, that has to be like mentally like a very tough thing to try to cope with and deal with. Pat, should we move on, talk about Chrystul Kizer here though?
Yeah, one last comment. I think that with the Christopher Tapp case, there might be a double jeopardy issue there in terms of he pleads to an Alford plea and then prosecution wants to refile. But I don't know.
No, I think that would be one of the reasons to take the Alford plea, is because then that's that. But if you don't take the Alford plea and they just the court exonerates you and throws out the conviction, if then the prosecutors refile, they could keep you in jail.
That sounds like double jeopardy to me, but I'm not sure.
Wait. So if they just threw out the conviction, right? They didn't like there's not an acquittal, then they could refile charges, right?
I'm not sure. I'd have to look into it.
Okay, I'm pretty sure that's. Sure. I know that I've seen it threatened before. Whether it happens or can't actually happen.
If the court throws out the charges without prejudice.
Yeah, right. Like yeah. I guess too, there's like a distinction of whether the court was granting a new trial versus throwing out the conviction too, right? Those may be two different legal standards that I'm conflating because I don't know the law.
Could be. Go ahead.
All right, let's go on to Kenosha and talk about Chrystul Kizer. We're back in Kenosha, Pat, already. And this is a self-defense case, and I'll let you go into it and talk about what happened here and what you think's important. But yeah, this is a young woman who killed her abuser.
Yeah, and so Chrystul Kizer, she's a young girl who was being sex trafficked. It wasn't clear if this if the I don't want to call him a victim, uh, but if the person who was killed, if he was a pimp or if he was some kind of a sex trafficker. But Randall Volar is his name, and she was charged with first degree intentional homicide along with some other charges because she went and murdered him. And I think from what I can tell, she was tried and then there was an appeal. There was an interlocutory appeal, which means that before trial there's an appeal on an issue, because you have to get approval before you can make a self-defense claim. And so she was going through and she was going to make an affirmative defense of self-defense. So that's saying, yes, I admit to killing him, but it was in self-defense. And they're using a new arm of Wisconsin statutes, which under Wisconsin statute 939.46 1M, there's an affirmative defense of coercion. And this is a new law that allows someone who's a victim of sex trafficking to bring the affirmative defense of resisting coercion, frankly, basically.
So
And
I guess just to kind of clarify what you're talking about there, Pat,
yeah,
you're talking about a situation where a young girl's life doesn't necessarily have to be like somebody could kill her right then or rape her right then, but if you are somebody who's essentially like has her kidnapped or held in a way against her will and is in the process of sexually abusing her, either yourself or for someone else to do it, that's cause for like lethal self-defense.
yeah, and that's my understanding. And my understanding is that this is the first time that this affirmative defense has been enacted for the resisting of being sex trafficked and for an intentional homicide. Or sorry, excuse me, at least for an intentional homicide. So it's being used to defend against an intentional homicide under the statute for the first time.
Okay. And so she kills the guy, and she ends up arrested and in jail and everything like that. So I don't know. I mean, how why bring the charges against her in the first place? I guess that's kind of the interesting part to me. It seems somewhat a clear cut case. I mean, right?
Yeah, I think the issue here is recency because it doesn't seem like, to me it doesn't appear that Kizer killed him while he was in the act of physically assaulting her. And I think that's the issue, is that so here's the background according to the appeal. According to the criminal complaint in June 2018, significant evidence led Kenosha detectives to interview 17-year-old Kizer in relation to the death of a Kenosha man. After lying to the detectives, Kizer admitted to taking an Uber from Milwaukee to the deceased's residence, shooting him because, quote, she had gotten upset and she was tired of him touching her, and then started a fire at the residence before departing in the deceased's BMW. Kizer was charged with first-degree intentional homicide, operating a motor vehicle without owner's consent, arson, possession of a firearm by a felon, and bail jumping, which are all felonies. And so they go further on. At a pretrial conference, Kizer discussed the applicability to her case of Wisconsin Statute 939.461M, which provides an affirmative defense for victims of human trafficking and child sex trafficking for, quote, any offense committed as a direct result of the violation of Wisconsin Statute 940.3022, which are the sex trafficking statutes. So that gives you a little bit of the legal background of this appeal.
All right. Well, so I guess the issue in her case is what they would argue that she wasn't like bound by this guy or something like that, and that's why it's questionable. But it seems like she felt like she couldn't do anything to prevent him from assaulting her again.
Right. Well, the issue on appeal was they say here in the opinion, quote, a victim of a violation of the sex trafficking statute has an affirmative defense for any offense committed as a direct result of the violation of the sex trafficking statutes, without regard to whether anyone was prosecuted or convicted for the violation of the sex trafficking statutes. So this issue is about whether or not what she did was an offense committed as a direct result of the violation of her being sex trafficked.
Okay.
So in my opinion, I think the court made the correct ruling here, just opening the door to her to present that offense. Now the jury can decide whether or not they buy it.
Yeah. So I guess there's a couple more things. It does seem like by the letter of it, what she said when she was arrested, I was tired of him touching me, right? That's like, she did it because she was tired of being abused by this guy. Yeah, and I guess an interesting part of this, Pat, is that would even be a law that would prevent somebody from raising this defense. I mean, doesn't it just work that anybody could raise any defense and whatever? This is something I addressed because of the Espionage Act, and an objection that like Edward Snowden and Julian Assange have to facing trial in the U.S. is that they couldn't even raise the issue that why they did it was to expose war crimes and everything. You can't argue that. And how exactly is that in like a criminal homicide case? You can't argue self-defense if that's what, no matter how crazy it is. You know what I mean? Like if some self-represented guy wearing a toga wants to go up there and kind of do his own cross-examination, like he should be allowed to do that and raise whatever points he wants. Now, whether that's going to like bode well for him with the jury is one thing, but that the court could like actually restrict that seems wrong.
I think it does. However, we can get into the philosophical difference between like positive law and the common law tradition. Positive law is something that's created by statute, and the common law is something that is created by case law. In this instance, the courts are guided by the legislature, especially in Wisconsin. That's how it works, is that the legislature sets up the frameworks for the procedure, and the court is bound to follow that procedure. And the procedure is that if you are going to present an affirmative defense, the court has to approve whether or not you can present that defense at trial. And that's what this interlocutory appeal is all about, is that my understanding at the circuit court level, her attorneys asked permission from the court to present the affirmative defense. The circuit court said no. They were appealed. Then now the appeals court is saying, yes, that's wrong. So you can get up there and present your own defense with the approval of the court. But of course, I mean, you're free to bring that, but you just have to get the court approval before the trial.
Yeah, it seems like a little bit of a scam.
Yeah.
Yeah, it seems like a way to, restrict and control what happens, especially in front of the jury. And, and this is a case where, unlike Kyle Rittenhouse, isn't, everybody doesn't know about it, right? So you could, like, legitimately have 12 people sitting on that jury who don't know who Chrystul Kizer is or anything like that. And if you're restricting what she's able to say and present in front of them, it could really tie her hands. And I think there are similar other things that happen like with Ross Ulbricht's trial too, right? They couldn't bring up a lot of the malfeasance, even if it was directly related to like what the FBI agents did and stole from Ross. Like that couldn't be brought up at trial. And it seems that these pre-trial kind of things are really just ways for the prosecutor, judge, the police to control what happens in the courtroom.
Yeah, I think that's the way it's effectively used. In a way, you're kind of breaking my brain, because this is very fundamental to my legal education and my legal experience, is the concept that all of these decisions are made before trial. Because what you're really doing is you're balancing rights in this case, because it would be a kangaroo court situation if both sides were just able to throw whatever evidence they wanted into the trial. to give a clear delivery of justice, you have to have a sieve. You have to have the court act in its function to determine what evidence is relevant, and the probative value unweighed by undue or outweighed by undue prejudice is what relevance is. So you have relevance here, which is made up of probative value, which what is whether something makes a fact more or less likely of being true, and undue prejudice. So in these examples that we gave, this is just the foundation of evidence here, is that you have these competing interests, and evidence can't be admitted if it's unduly prejudicial. Like I don't know, if I was walking into the store and I'm being charged with stealing something from the store, if we go into the trial and someone says, well, you know, Patrick is an anarchist, how does, you know, that's unduly prejudicial, and it's going to make the jury think that I'm guilty because I'm an anarchist. So you have to make those calls. But I see what you mean. It's like, you know, the jury, these evidential rules seem to be like what the judge and the prosecution used to railroad people like Ross Ulbricht.
Yeah, I think it's very much weaponized. And just,
Yes.
I guess to go back or push back on that, I mean, there is like perjury, you know, is illegal, and prosecutors like seemingly would not be able to like just lie, right? Like they couldn't like bring false evidence that would like be something that would be held against them. I guess though you do make a good point, especially when it comes to like reputation. If you know you got like somebody who like went crazy 10 years ago and beat up some old lady, right? And then, you know, now 10 years later, they robbed, you know, a convenience store, and the you know, prosecutor puts you beating the old lady up there. Well, everybody's going to convict you of everything, right? And even if that's like maybe unfair, it's not exactly untrue. And you know, I do see those kind of things causing some problems. But anything else on the Chrystul Kizer case? Is there, I guess, do you have like a thought on how it may go in the, you know, Wisconsin courts? If it, I mean, obviously we have our own opinions, but you know, there's what's the truth and what should be, and then how things will go in an American courtroom.
I think it's interesting. I think it depends on what the makeup of the jury is, and how good the defense counsel can do. I would assume that she's being represented by the public defender's office. Maybe that's an unfair assumption for me to make, but it's an interesting legal question. I'll say that, because you have a novel application of the law. You have an interesting kind of factual argument, and I guess in a sense it's a legal argument. Is this a direct result? It's statutory interpretation. What does direct result mean in this case? And I think that's just from my own legal brain. I think that's a really interesting question. So we'll see how it gets addressed. It could be that she's not allowed to present the self-defense argument. Then I think she might be screwed, unless there's like some kind of a jury nullification that takes place where they refuse to convict her because of her circumstance. Do you remember that case, the famous case of the pedophile who was being walked past a telephone booth, and the dad of the victim?
I know the video. I don't remember like the details of the case at all.
I believe that the father was convicted of homicide, but he was given like a very light sentence, and I wonder if that would be the case in this. I know that the judge has more power to do the sentencing.
Yeah, that is one of the last point I was actually going to bring up on this, is that, you know, especially when you live in a country like as big as the US, as many people in the United, like, not that this is like, you know, something that like is absurd that like a girl is being sex trafficked, but you know, things that don't really fit into everyday law are going to happen. And that's why like pardons exist and why judges should have discretion, is, you know, for cases like this, you know, maybe it really isn't that you have to like have a particular law, or the court system has to be able to like function in a way that, justice for this girl, she's able to go free, but the governor just grants a pardon, and that's like, clean, quick, simple way of handling cases like this. And part of me thinks like that's more the solution here, because I do kind of understand. Not, I guess I'm not necessarily worried if, like, sex trafficking victims just all feel empowered tomorrow to go out and start shooting their abusers, but mistakes happen, and you don't really want people just going out and getting their own justice by carrying out homicides. That's a dangerous route to go on.
Yeah, it is, certainly. And I mean, in a more just system, because I mean, I always remember that it's the prosecution is the executive branch of the state. Prosecutors are part of the executive branch, and so the state gets to pursue charges on its own discretion. And in a situation, I think the onus would be on the family of this sex trafficker to try to pursue prosecution, or some kind of, I don't know, in a society that we envision, Kyle, it would be, it wouldn't be a monopolized system like the state decides whether or not they're going to charge this. And I think the answer is almost always yes. A homicide was committed, we're going to charge it. And this goes back to Rothbard. I mean, talking about wrongful convictions and pretrial detention. If you decide to charge this out and you ultimately lose at trial, well, there's going to be there's going to be something that you have to pay.
Yeah. And, just to kind of tie this in with the Kevin Strickland, and something I cover on the show a lot, and that is exonerations that happen after, extended period of time, or for major crimes like homicides, rapes, and stuff like that. And it happens really frequently, Pat, that, the person that the state put behind jails or brought charges against isn't the person that's guilty of the crime. And so, how many more people, I guess, are being victimized, because it's not like the conviction rate for murders is very high, right? As is. So it's not like they're catching everybody that, every murder, they're throwing somebody in jail. That's not what's happening. But even when they do actually arrest somebody, get them and throw them in jail, it's often not the actual murderer. And so how many other crimes do you have going on, particularly like sexual crimes, that, especially if somebody's like raping women and getting away with it, I don't imagine that they're going to stop. And if you keep arresting other people for the crime, which, I'm not saying like all the time, like, one guy rapes 3 women and 3 other guys go to prison, but, maybe one of them, they actually do the rape test, and it doesn't turn up anything, and then the other one, the lady identifies some other guy, and so, and the third woman doesn't come forward or something, so you raped 3 girls and got away with it. I don't know, people probably aren't going to stop, right? And so how much crime do you have going on? How many victims do you have like Chrystul Kizer that only exists because the court system can do its job in the first place?
Yeah, that's a good question. I mean, there's the seen and the unseen. I don't know if that's the best use of that phrase, but there is. I mean, we don't know purely how bad a monopoly justice system is. We get hints of it, but I'm sure it's much worse.
All right, let's talk about this next killing. It was a man in the wheelchair at either a Walmart or a Lowe's parking lot. I think it started at Walmart and ended at Lowe's. It's an elderly man, Richard Lee Richards. He's 61 and confined to a wheelchair. And Pat, this is maybe the most unbelievable police shooting I've ever seen. Obviously, like, something like George Floyd's a little bit different because of how long it took, but I don't know if I've ever seen a police officer unload on a guy in a wheelchair for having a knife. There's been times where unarmed people in a wheelchair were killed because police claimed they thought he had a gun, but I mean, this was crazy. So I'll let you, talk about what you think is important. By the way, the murderer here, the officer that shot Richard Lee Richards, is Ryan Remington.
Yeah, so Richard Lee Richards, he was an older man confined to a wheelchair. Just seems like a petty theft. He stole a small wooden toolbox, and he was exiting a Walmart and going into a Lowe's store, ostensibly maybe to steal more things, continue his petty theft And so he's going and he's followed by the police officer. Now, he was accused of wielding a knife against a, what do they call that? A resource officer, someone that worked like a security officer from Walmart. And then the Remington, the police officer, comes and he just kind of follows him at gunpoint because at one point Richards pulled the knife again. I don't know if he wielded it or if he swung the knife or did anything like that, which, I mean, the guy's confined to a wheelchair, which doesn't travel very fast. And so I guess he could throw it at you maybe, but the wheelchair doesn't move very fast. So if he's going to come at you and stab you, I think you would have the ability to escape. And so Remington follows him through the parking lot. He's on the radio the whole time. And it's when another officer arrives and Richards is about to enter the Lowe's store. The other officer comes up and is yelling some commands like to stop, don't go into the store. And before the second responding officer can finish what they're saying, Remington unloads his magazine, it seems like, into the back of Richards, and Richards slumps over and dies.
Yeah, and so just a couple of the, I guess, details of that was so surprising to me, Pat, is, this is a man in a wheelchair, right? Like this should be one of the easiest people to disable for the police. And, not that I want the cops to go around tipping people out of wheelchairs or something like that, but if the guy has a knife and, if you feel like there may be somebody's life that's actually in danger, like a store worker or something like that, like, and you gotta throw him out of his wheelchair, then throw him out of his wheelchair. Like, there are solutions to this. Or, this is a Lowe's, like, go grab, like, just a big piece of wood, a railroad tie, and throw it in front, or a couple landscaping blots or something. There's ways to box this guy in, even using police cars or stuff like that you would, have to shoot. It seems really unbelievable here. But then, and I know sometimes that, like, once people start pulling the trigger, they just kind of unload the whole clip. But this guy didn't, like, fire all of his shots and like the officer did against James Blake. It was kind of spaced out. And then another concern I have here is it kind of seems to me that, and this is just from observations and what happened, that we know about, that Richard Lee Richards may have been something of like a vagrant, or like a general public nuisance. And I don't mean this to, like, dehumanize the guy. I spent time, like, after I got out of college working with people with schizophrenia, and I know that, like, I really like the people, but if you have somebody that walks around town all day walking up to people asking them for money and cigarettes, like, and especially when people are, like, unclean and sometimes, like, stuttering and stumbling, and also, like, have other things going on, like, potentially it could be intimidating, especially to, like, younger people, and, like, they don't realize it. And so, like, I'm not saying that, like, you just gotta let this guy do whatever. Like, I understand that there's problems and consequences to that, but there's doing nothing and then they're shooting him in the back 9 times. And, there's a very, very big, gap between the two. And so, another thing to just note about all this, that the guy in charge of this police department, or the police chief here, is Chief Magnus, who Biden just nominated to head up ICE. So he's getting a promotion, I guess. I don't think the cop is going to jail. And I mean, I don't know. Obviously, Pat, if you're the prosecutor or whoever the hell, you're bringing charges against this guy. But what do you think are the chances that he actually goes to jail or gets prosecuted, especially because he, as stupid as this is, again, there's the truth, there's justice, and then there's the American courtroom. Richards had a knife.
Right. Yeah. I mean, what it really depends on is, from my understanding, is whether or not he acted according to his training, because I think the standard is going to be set by, it could be in a civil case if the family sues. I'm not sure about, like, what the criminal elements are, the protections for police officers, but I know that something of issue is whether or not they are acting according to their training. whether it was reasonable according to his training, which really seems to me to be a subjective kind of standard, is, well, we'll bring in evidence about what training he had and what was taught in the training. But I'm confusing that with a different story that we were going to cover. But I don't know. I mean, this has like a reverse Rittenhouse effect. It's like, so in the Rittenhouse case, Kyle Rittenhouse is carrying an AR-15 ostensibly to protect a car dealership from violent rioters and looters. And the violent rioters, when Kyle Rittenhouse tries to stop them from being violent and destroying property, they get violent with him and he has to use deadly force. So Kyle Rittenhouse gets charged for doing that, but the police doesn't, this police officer doesn't have charges against him for doing kind of the same thing,
Well, I mean, the guy who has bad to him, so I guess it's a little bit different. And I mean, Rosenbaum was certainly more of a threat than Richards, but yeah, there is certainly a very crazy comparison there when you're looking between these two cases and who's going to get charged and or likely go to jail and who isn't.
Yeah.
Do you want to move on and talk about the price of prison phone calls? This is a really important issue that doesn't get talked about very often, Pat, and it's expensive. What does the article say here? I think like the average 15-minute call in the United States, if you're in prison, costs $5.75, and this is often picked up by the person you're calling and not yourself, or it's taken from your commissary money at the prison. And so yeah, I mean, I don't know if you've ever I don't think you've done a whole lot of criminal law, Pat, but I don't know if you've ever had to talk to somebody in jail. I had to do a couple calls, but I was calling from because of my job or whatever, the call didn't get charged through the prison, but it's a kind of a pain to call somebody in prison. So anyways, I was just wondering what your thoughts on all this are.
Yeah, most of the representation I've done, I physically went into the jail and spoke to my clients. So I haven't done a whole lot of calling people in prison. But it's just a racket. I mean, it can't cost that much money to have a phone service. And if it does cost that much money to have a phone service, then you have a serious problem. I mean, if you get to socialize the cost, there's no incentive for the phone call to be as cheap as possible and yet provide that functionality.
Yeah. And I guess one of the things about this that seems so cruel, Pat, is as much as it may in a way punish the person who's in jail, and who there are people in American prisons who have committed actual violent crimes and should be in jail, and are people you don't want on the streets. And if you commit a sex crime against a child, I really don't care if your phone calls cost $5.75. But that's not the vast majority of people in American prisons. And even in that person's case, sometimes the phone call is more for the person on the receiving end who hasn't committed a crime or anything like that. And so in a lot of these cases, some kids doing a year or something for selling drugs, and the phone call, I'm sure, is more for his mom than for him, right? She wants to hear from him and alleviate her anxieties about how things are going for whatever's going on, to talk to her baby and everything. And that you're charging her this amount of money, that if you're from a low income community, which disproportionately people from in jail are, then this could be significant. If you want to have let's say 3 phone calls a week for 15 minutes each, that's almost $20. That's not nothing. That's something you have to budget for. That's not money you could shake out of the couch cushions, especially when you're talking on a monthly rate. We're talking about $80, maybe even $100 a month, especially, things are hard for somebody in jail and they're having longer conversations. Also, I'm sure, they always round up, and if you end up in federal prison, they ship you all over the country, or if you're in a larger state and it's even in state prison systems, it could be, I don't know if they charge actually long distance anymore, but if you're probably on like a rural landline, they do. um Maybe not if you're calling from a cell phone, but there's, I'm sure, all kinds of way they tack on charges and stuff too.
Oh yeah, definitely. And here's this line: the correctional telecom industry rakes in more than 1.4 billion dollars annually from prisoner phone calls. That's just, I mean, going off what I was saying earlier, just seems like you have this budget that's provided by the state, and that's just a cash cow for these industries to charge whatever they want.
Yeah. Well, Pat, we have to boycott the Olympics in China because the Chinese are bad to the Uyghurs. Didn't you see that one detention camp? America doesn't do anything like that ever. Um, let's see. Is there any other ones that you want to touch on here, Pat? Do you want to mention the NARC-2 drug test? I've talked about these in the past on the show, but this is a court ruling that kind of confirms a lot of what I've said about these particular drug tests, but drug field tests in general, which is they result in false positives, but they're also very easy for police to generate false positives with. And so you have a lot of cases where, if you have false positives like 10% of the time and you do 5 tests, well, now you're on a coin flip of, if the dust from the drywall, because you're a construction worker, or I think I did a recent story with a woman named Miss Goldring who spent 6 months in jail because they cut open an exercise ball. So Pat, what do you have any experience with these tests, or what's the details from this story?
I don't have any personal experience with these tests. However, it just reminds me of the PCR test, and I'm talking about the COVID PCR test, the ones that they use to determine whether or not someone has COVID. And from my understanding, it's like, blowing up a picture 5 different times, and you blow up something enough times, you're going to find anything you want in it, and it just becomes unreliable. But in the same way as the COVID PCR tests, it seems like with this NARC drug tests that they start using it, and then the onus is on like defense attorneys to make them stop using it, right? So they establish this as being the baseline for arresting all these people, but the only way to overturn it is just a whole lot of work and effort and people losing their lives, basically, trying to get that overturned.
Yeah, and one of the real problems here, and especially since we're talking about Massachusetts, is that so police turn up a NARC-2 positive test on someone, right? And Pat, you think worst case scenario, right, is that if it's a false positive, they do the field test, but the idea of the field test is to give them a general idea of what it is, but they send it to the drug lab, and then the drug lab uses real science and pipettes and microscopes and everything, and they're gonna make sure that they know for sure what that is. And then within a couple of days, if it's wrong, which it usually isn't, but if it's wrong, they get the person out of jail and they make everything right. And that's not what happens. People spend absolute months in jail or even longer because all these drug labs are absolutely backed up. But particularly in Massachusetts, there was 2 women who are working in drug labs who fabricated thousands of results potentially, and just for months. I think one person actually for years was just, she would test one thing and then do the results for 10. And so if it was positive to the results for 10, they were doing all the drugs, stealing the drugs, and then faking drug test results for that reason. And so even if it goes to the drug lab, that doesn't necessarily mean that you're going to get a correct result or that you're going to get that result in any kind of a timely manner. But on top of that, they could just straight up fake it. Like, you don't know. Like, it's just some person that probably has a college degree, not like a chemistry degree or anything like that in a lot of cases, who's doing hundreds of these things a week. And it's just their job. They take a little bit, they put on thing. Not to mention that you put people in a room with they send over the cocaine, right? So like that has to be tempting to a lot of people, right? To just like have a bunch of cocaine sitting there, especially when you just got to sit there and test it and like see what it is and what's in it, and like You know that's the good stuff. Like, are you just gonna be like, yeah, like just, and not everybody, but like, that's temptation and moral hazard and all that. But these people have godlike authority over everybody else's lives in the state. And so it's a huge deal if you end up behind bars. And it all starts with a very easily incorrect drug test. So, Pat, anyways, anything else?
Yeah, it seems like there's a potential for cross contamination here. And I was just, thinking about if it goes down to a coin flip, if we do the test and it goes down to a coin flip, that would seem like what the officers, I'm sure, are going for probable cause. And a lot of people think that probable cause means 50%, right? Well, probable cause is lower than that. Like if you wanted to put a percentage on it, it might be 40%, 35 to 40% probability. So if you say that this test is 50% accurate and you get a positive, then that right there would be your probable cause, I would think. I'm just kind of postulating.
Yeah, no, it's funny because like probable cause is essentially like I I'm going to fabricate this story in my head, and there's nothing directly in front of me that forces it to be debunked, so I'm going to assume it's true.
Yeah.
Right? Like that's just the way it goes. All right, Pat. Well, we should wrap up there, but this has been absolutely great, and thanks for coming on, breaking down all these stories with me. I really like covering the police stuff in the U.S., but sometimes, if you don't have a little bit more of a legal background, some of the ways that the stories are covered are confusing, either because the journalists are trying to cover up for what the state is doing, or you just don't understand the court scam, right? And you gotta like have that legal law degree to understand how they actually like put all the processes in place to generate the kind of results that they want.
Yeah, and it's even hard too, Kyle. And I would encourage people, if you really care about these issues, to get your hands on the court documents themselves, because oftentimes, even from stories, you're getting a secondhand story. Like the the case we talked about earlier, was it Chris Tapp? That it's hard to know exactly what the procedure is and things like that. So it's best to read the documents themselves. They're written in English, and you can learn a lot of things just from them and get a better thing, because a lot of times, sometimes you can get mad at the court for certain procedures when it just helps to dissect them when you know what those procedures are and what the court's reasoning is. You sound a lot more credible when you talk about it, and your arguments stick better if you have a conception of what's going on. And if you get your hands on the decision, I'll send you the link from this the case we talked about in Kenosha, the Kizer case.
Yeah.
People can read that and kind of grapple with the legal issues at play there. And sorry to hijack you, Kyle. One last thing I wanted to say about this, the wheelchair case.
All right, go for it.
I just meant to say that Richard Lee in this situation, Richard Lee Richards did not pose a threat to Officer Remington, whereas in the Kyle Rittenhouse case, it's clear that people were posing a threat to him. So I'm just trying to say that in that case, Rittenhouse is the one who gets charged, but Remington will not be charged.
Yeah, you're just pointing out the absurdity, the difference in the absurdity of the contrast between the two. But sometimes libertarians, despite all their grandstanding on how well they do nuance, don't do nuance very well. So it's probably great that you point that out. And I was gonna say something else, but whatever. Everybody, check out Liberty Weekly. It's an absolutely great show. You did a couple great episodes recently. Monica Perez, and I forget who her co-host is. I'm sorry. And go ahead, Brad.
Yep.
And then Adam Fitzgerald, who is absolutely great, and you had him on, and you guys talked about a lot of stuff and that was a really important show, and something that libertarians should listen to and understand how the U.S. intelligence community has operated in the past, and just think a little bit about that and like what's probably going on today. So much great stuff on your show, Pat, and in the articles you've written and the work you've done, especially on the Uyghur issue. Everybody check out Patrick MacFarlane at the Libertarian Institute and at Liberty Weekly. Was it _Liberty Weekly on Twitter?
Yeah, I think it's Liberty_Weekly.
One of these days I'm gonna get it, dude. Liberty_Weekly. Thanks, Pat.
Thanks.